for making it. I apologize for the cramped quarters. It is a good problem to have, I guess, if you're DAU. To have a lot of people want to come to this training, but it's not really DAU. It's Diane Sidebottom, who we've brought down here. Diane is a learning director, a brand new learning director at DAU for other transactions and grants. We've been lucky to bring her on. She's been with us for just a few months, and as you can tell by everybody that's in the classroom and everybody that unfortunately was turned away, and hopefully we'll make it one of the next 2 days, OTAs is a new, not so new, a new flavor of a big sexy thing, at least for the next year. We don't know how long the wave is going to last, right? So lucky for us, Diane has been doing OTAs before OTAs were cool. We brought her on from DARPA, and she's got a lot, 20 plus years of experience with OTAs. So she's going to be sitting here. She's going to tell you the facts, no kidding, the hard facts about OTAs. Maybe they're not the silver bullet for everything, right? She's also going to debuff some of the myths that are out there about OTAs as well. We're planning for this to go about 2 hours, all right, with some Q&As on the end. She's probably going to explain that a little bit more. And then if you're still just, oh, you know what, I want more OTA. Jed, I can't get enough OTA type stuff. I live and breathe OTA type stuff. Diane is still your belly button within DAU. We'll get you to interface with her at the end of class. You guys can exchange business cards. And DAU actually does more stuff than just in-classroom things. She can come out to your unit. We can arrange some kind of performance learning mission assistance type of effort, right? So with all that said, thank you so much, Diane, for coming down to Huntsville from the Beltline, and good luck the next couple hours with this rowdy group.
Okay, thanks. Thank you. Okay, it was nice to see so many people interested. We're going to be taping this today, so unlike what I would normally do, which is let you ask questions whenever they occur to you, I'm going to ask you to hold them until we're done, just so that the tape will show the presentation, and then once I'm finished, we'll turn that off, and then you can ask as many questions as you want. That'll help with the non-attribution aspect of it too, so you won't be on videotape. So, okay, so as Jed said, I've been doing these for a long time. I started my career pretty much at DARPA back in 1994, and that's when OTs for prototypes began. That was the first year that we got that authority. DARPA basically created the DoD version of OTs. And so I've been doing these kind of arrangements ever since, and so that's why I find it kind of funny, and I always laugh when people call it new. It's actually not new. The original authority was passed in 1989, so it's been around for a long time. But as with many things that are acquisition reform-like, you know, it tends to ebb and flow, where it's popular for a while and then it kind of dies off for a bit and then comes popular again. So we're kind of riding the second wave of this quest to do OTs, and it's nice to see this time around how many people are interested, because there certainly wasn't this level of interest the first time around. And the advantage for you all is it's been done for a long time, so you will not be the first. You will not, you know, be the first ones to try this. You will not have the same level of scrutiny that we had on the original go-around, which is good and makes people feel a little bit more comfortable. And I can honestly say that no one's gone to jail and no one got fired ever, so that should make you feel a little bit more comfortable as well. The other thing I should say up front too, just in the interest of full disclosure, is I'm not a contracting person, I'm actually a lawyer. So I've always been on that end of things, but when you do OTs, it's pretty much an integrated team that you're going to want to have. So the legal folks, the contracting folks, and the program folks tend to work very closely together in these kinds of arrangements. Okay. All right, so it is important to understand a little bit about how OTs came about, because this will put this in the right framework of what these arrangements are really here to try to do. And what they're focusing on is science and technology development. That's why they were created, was to help us. Does everybody have turned their phones on vibrate if you can, just in case? The science and technology world has changed quite a bit. If you look back 40 or 50 years and you look to see who in the United States was investing in science and technology development, you pretty much can find two groups of folks. One was the government, and the other was universities. And the government was a huge driver in investing in new technologies, and we've seen that over the years when we see some of these technologies become commercial technologies, things like GPS and microwave ovens and the mouse for your computer and a few other things. And so the government really was the one who was pushing a lot of these new ideas and these new innovations because they needed it for military purposes, and then it kind of morphed over into commercial purposes. But about 30 years ago, that all shifted. And there's no one point you can point to, but in my mind, it shifted when IT became so popular, computers, and they became so mainstream. And that's when you start to see a lot of this dynamic change, and the investment started to come from the private sector. The government was still investing, but the private sector started to invest extremely heavily in science and technology, and particularly cyber at that initial stage, but then it's morphed into all kinds of different areas. And so nowadays, when you go out and you look, the main investors in S&T is no longer the government. It is the private sector, and they are investing billions and billions of dollars. And they're investing and making those products come out faster and faster and faster to maintain a competitive edge, which sort of puts the government in an awkward position. Because when the government was the main driver of technology, we could pretty much demand whatever we wanted in terms of contracting, in terms of how they were going to run programs and run these kind of technology programs. Now that the private sector are the ones who are the main drivers, they don't view the government in many ways as a major customer anymore. They don't need our money necessarily. And so when we go to them and we ask them to do things like FAR-based contracts, where we hand them this scary big stack of papers and say, here you go, it's take it or leave it, in a lot of cases they'll go, yeah, I don't really need your money, which puts us in an awkward position, right? Have you ever had somebody who tells you that you want to buy something from them and they don't care to work with you? The first time that happens to you, you kind of sit there stunned, wondering, now what do we do? And contrary to popular belief, you do not have to take a contract from the government just because we want to give you one. There's an amazing number of people who think that's the case. Only in times of war can we force people to take contracts, and we're not technically having one. And so DARPA actually ran across this situation much earlier than a lot of agencies did because of the high-tech nature of what they did. DARPA is a Defense Advanced Research Projects agency. They do all the high-tech R&D for DoD. And back in the late 80s, we started to see this problem of us approaching big companies, especially big computer companies, and they would say, no, we're not going to do that. You're just not a big enough customer for us, and we don't want to change our practices and policies just to accommodate you. And so that really made us sit back and think, well, what are we going to do now? Because this problem's only going to get worse and worse and worse. We've got to come up with an alternative way to work with these folks, and that's how OTs were born. Was to give us another way to reach out to folks and behave much more like a commercial company to draw these people into working with the government so that we can access their investments and their good ideas so that we can use them for future military purposes. So it's important to recognize that so that we understand exactly what OTs are for. OTs are an R&D instrument. They are a research and development acquisition tool. And I say this, and I'm going to say it several times, only because I've been getting a lot of calls from folks lately asking me, well, can we buy seed to sport contracts with OTs? No, there's nothing science and technology about that. You know, can we buy computers? Well, maybe, maybe not. It depends on what it is you're doing with them and whether or not there's an R&D aspect to this. So, at its heart, OTs are a research and development tool. And that's what we're going to focus on, and you're going to see that when we look at the actual statutory language. Okay. So, in this last go-round of acquisition reform, and if you all have been in the government any length of time, you've seen that there's been a lot of promotion from the Pentagon and others about changing the way we do business. Now, we always talk about this, don't necessarily actually ever accomplish it. We've got a big behemoth of regulations and policies. It's very difficult to make that sort of shift. And anytime you try to make a cultural shift, it's always going to be difficult, right? Because we tend to get ingrained with what we're used to. If many of you remember when Mr. Kendall was at the Pentagon, they were doing the Better Buying Powers, all of which were focused on trying to make us more efficient, more effective, quicker, and be able to reach out to some of these other kinds of technology providers who might not ordinarily work with us. And we've started to set up some offices. DoD has now set up some different offices within certain target groups, specifically Silicon Valley and some others, who have traditionally shied away from us altogether. And they definitely don't need our money. Do you really think Microsoft would curl up and die if we never did business with them again? Probably not. I think they got more money than we do. So we need a way to try to approach these people on their own turf, to talk their language, to deal with them as any other commercial customer would. And so you have offices like DIUX and a few others who've been set up to specifically address these purposes. But it's not just those kind of folks that we need to address. Many of you will see that even in some of our more traditional military-like systems, It may not be the system that you buy off the shelf, like a tank or a plane, but a lot of the component parts of those systems are going to be commercial items or somewhat commercial or have a commercial aspect to them. And we want to be able to reach out to these folks across DoD, not just within these unique specialty areas. So, about every 10 years, OSD puts out an RFI asking industry what they dislike about working with the government. You kind of wonder why you do that, because you just know it's not going to be pretty, right? What's interesting is they tend to get the same answers all the time, which also makes you wonder why lots of things haven't changed. But these are the typical 4 answers that we get anytime we talk to industry about why dealing with the government is so difficult. And I'm sure the first one is something that you all have experienced as well. Traditional procurement contracting is too slow. It takes us a long time to get our act together, a long time to write our solicitations. Now, obviously, we're often working with very complex systems, which takes some time to think about and plan for. But in a lot of cases, it's even the smaller stuff that takes us a long time. And a lot of that's because it's process-driven and compliance-driven as opposed to looking towards efficiencies. We need a way to pick up the pace a bit, because think about some of these technology areas. Like if you look at software, what's the life cycle of software? It's anywhere from 8 to 18 months. Can we get a solicitation out on the street and awarded usually in that time? Not a lot of organizations. And so we need to find a way to do this faster. But one thing I do want to emphasize here, and I'm going to say it again later as well, you should not do OTs just because they're fast, because they may not be fast for you. You have to embrace the whole concept of this flexibility in order to make this quick. And if you don't do that, it may take just as long or even longer, because there's going to be a lot of things that will be new and different that you'll have to address and get used to. OTs were created to help us attract non-traditional contractors. That is the main focus. They are not created to help you do things quicker. That's a side effect if you embrace the concept of OTs well. But just keep in mind, the main goal is to attract non-traditional contractors. Traditional procurement contracts, private sector doesn't like them because they're contracting based by regulation. I know Part 15 is called contracting by negotiation, but it isn't really. If you think about it, how much of a traditional procurement contract do we negotiate? You don't negotiate any of the terms and conditions, right? Half the time we don't read the terms and conditions. We just put them in there because the system says to do it. We negotiate rates and statement of work, right? That's pretty much it. Well, that's not how the private sector does it. The private sector negotiates all the terms and conditions for that unique situation. And they come together as a team to decide what is the best solution for this particular circumstance. And so when you throw a big pile of documents at them and say, here, take it or leave it, a lot of times they'll go, leave it. They won't even read it. They don't want to figure out what all those clauses are or how they all work, and half of them don't even apply to them. It's not a construct that they're used to. They also dislike how we do our cost-based pricing system. Nobody in the world does it like we do. And if you were to run a business, would this be the way that you would choose, is to do contract pricing the way the government does it? Probably not. It's cumbersome, it's time-consuming, it's expensive for them to do because you need a lot of people to run it and maintain it so it's compliant. It doesn't usually in any way resemble what they're doing within their own business space. So they're generally using generally accepted accounting principles and having audits from independent auditors. They just don't like changing over their system for 1 or 2 government contracts. It's not realistic. Now, if you're working with traditional defense contractors, they're not going to mind because already they're set up to do that. But for a lot of these folks, we have to find a different way that we can look at their costs and their prices and come up with a way to assess that what they're asking or charging us is reasonable without making them go through the whole CAS system and cost principles and all that sort of thing. And then finally, for a lot of them, the way we handle intellectual property is not going to work for them. We have some structure to our intellectual property systems that doesn't give us a lot of leeway when it comes to patents. It's pretty one position is all you got because it's statutory. We can negotiate our approach to data, but we generally don't in the traditional government system. And that's largely because of education, right? We're not really taught, any of us, lawyers, contracting officers, to understand intellectual property, to understand all the nuances, and to know how to negotiate that. So we tend not to. We just tend to pick one of the standard clauses from the FAR, or the DFARS, and that doesn't work for private sector. Think about a lot of these companies. What is their asset? It's their intellectual property. That's what they've got, and that's what they build their whole business on. They want to turn over unlimited rights to us so we can do with it whatever we want? No, they're not going to do that. So we have to come up with another way to negotiate and assess and come up with some reasonable approach to intellectual property, because the traditional system just doesn't work for most of these guys. So all of that led to the creation of the other transactions. And so there are several agencies that have this authority. It's not just DoD. There's actually 9 different civilian agencies that have it as well. And DoD didn't even really create it. It actually was created by NASA. They call it something else, but they actually has had this authority since 1958. And the reason that we have it in the way we do here at DoD is because my old boss, who was the general counsel at DARPA, had come from NASA before he came to DoD. And he had seen that they had this authority and they rarely ever used it because the lawyers were in charge of it and they wouldn't let it out. Because lawyers tend to be fairly risk adverse. And so he thought that was very sad. And when we started to see some of these problems that DARPA was having in particular in reaching out to some of these high-tech firms, he thought that the OT authority would be the perfect solution to this. Give us the ability to negotiate, to be more flexible. And so basically took the NASA authority and changed it a bit for DoD. And so that original authority is the other transactions for research, which is known within DoD as TIAs, Technology Investment Agreements, is at 2371, 10 U.S.C. 2371, and that was passed in 1989. Now, originally, only DARPA had the ability to use it. It was kind of a pilot project. And then in 1992, the rest of the agencies received it as well within DoD. So since 1992, all the military services and the defense agencies can ask OSD for a delegation to use other transactions for research. Then in 1994, this seemed to be going so well. So in 1994, we went back to Congress, DARPA did, and asked for the ability to take it beyond the research projects and into acquisition, where we actually were going to acquire something, a good or service for the direct benefit of the government. And that's where the OTs for prototypes came along. So in 1994, Congress gave the OT for prototype authority to DARPA, again, solely, to go out and do some projects where we're actually going to acquire prototypes that would be brought back into the inventory. And that is at 10 U.S.C. 2371B. In 1996, the authority was extended to the rest of DoD. So you can see that it's been around for quite a long time. It's just that because it is such a different construct than what we're used to, a lot of agencies shied away from using it. Because it is definitely a different thought process and mindset and culture from what we're normally accustomed to. But it is important that you remember that there's 2 different authorities, because a lot of people solely focus on the OTs for prototypes, and not everything is going to fit within that authority. Now, there's no guidance really on this, on how you make the distinction, and I'll tell you how I normally do it, just so you can use that as sort of a baseline. If I look at a project and I'm thinking, what is our main goal in this project? Is it to push the state of the art, to try to make sure that we can prove this technology, whatever it is we're trying to do? And in order to show that it was successful, we need to build a test vehicle or 2 so we can test out the technology and see if it actually proved out. But we have no intention of taking that test vehicle. In fact, we assume that it will be consumed in testing. That would be a TIA, an OT for research. If, on the other hand, my whole goal is to get a prototype, that's what I go in this for. I want to have a prototype at the end of this that I can take into the inventory and use within the services or within one of the other forums within DoD. And in order to build that prototype, I have to do a lot of research to get there. That's an OT for prototype. So it can be a fine, fuzzy line there, I'll give you. So it's just going to be an assessment of what is your goal in this project and what it is that you're trying to achieve and what do you expect the end state to be. And I will tell you that in recent years, much more OTs for prototypes than OTs for research, but I would be willing to bet that if I looked at a lot of them should have been OTs for research. Okay. Oops, sorry, I'm used to someone changing charts for me, and they're not going to. Okay, so how do you solicit for another transaction? Well, you wouldn't use an RFP, and I would never call it an RFP. We're all familiar with RFPs, right? Request for proposal. It's a very generic name, but in the traditional procurement world, there is a definite connotation to using the term RFP, right? And one of the things you'll notice as you get into OTs is that a lot of the names of things have changed. And that was on purpose. We actually used to go out of our way to change the names of things. Because what we were trying to make sure people didn't do was assume they understood how something worked because of the name. So if I call something an RFP, what's people's natural inclination going to be? It's going to think Part 15, right? Because that's what we're used to and that's what we normally associate with RFPs. but RFPs are generally for traditional procurement contracts. So there's other ways that you can solicit, especially if all you're interested is in OTs. Now, one way, and the way many agencies will do it, is through broad agency announcements, or BAAs. Has everybody heard of BAAs? Okay. So BAAs are under Part 35 of the FAR. So the process itself is still a FAR-driven process. But under a BAA, you can award any instrument. You can award a traditional procurement contract, a grant, a cooperative agreement, an OT of other varieties. And if you look at a lot of the BAAs, that is what they say, is that they will be determined down the road once we see the proposal and we see what it is that you're trying to do as to what instrument you should get. But it is important that you recognize if you go the BAA route, you will be limited to some degree. BAAs can't be that specific, right? Right? No, they can't. That's why they're broad. They're not supposed to target a specific solution. They're not supposed to have too many requirements because you're supposed to be covering broad technology areas. And so that can somewhat limit what your project might be, and that may not be useful to you. Also, because the process is under the FAR, what can happen to your process? It can get protested because the FAR-driven process has that downside as well. Now, as we know, most BAs don't, just because of the nature of how they work, but it is possible. But you can come up with other solicitation types, and that is one area where you can start to think a little bit broadly. If you still want to award grants and cooperative agreements, but you've decided you don't want to award contracts, we at DARPA came up with a solicitation called a research announcement. And so with a research announcement, we made a decision up front. No procurement contracts. These are going to be assistance type arrangements, and so we're going to award grants, cooperative agreements, or other transactions. Now, how did we come up with the name research announcement? We made it up. So that's what I'm saying. Don't think like you have to find a name that already exists. We made it up. There's no guidance on this, but it's also never mentioned in the FAR. So what does that get you out from under? All the FAR-related stuff. Now, there are certain circumstances where you know up front all you're going to want to award is OTs. You've made that call. You know that that's the way you want to go. And so then you can come up with your own solicitation type. We called ours program solicitations, which we also made up, and I'll give you, it's not super inventive, so find a sexier name than that. You may have heard of some of the other ones. For instance, DIUX uses something called Commercial Solutions Opening, or CSO. That's their form of solicitation. By the way, they made that name up too. And so be creative and come up with whatever name you like. But once you get out of the FAR-based world, and to some degree the grant-based world, you have a lot more flexibility, and there's really no guidance or dictation on what you need to call these things. Just make sure that you are clear to the offerors, though. You want to make sure that no one gets confused, that they understand that this is, in fact, a solicitation. You're looking for proposals or offers. And we want to make sure to be as transparent as we can be with the private sector. And so your process then will not have any sort of book or guide that you can go look to for how the process is supposed to go. So it's going to be governed solely by the document itself. So you want to make sure that whatever process you come up with within that document is reasonable, is easy to do. One thing I find that a lot of people do is, left to their own devices, they make a really hard process. Why would you do that to yourself? You know, the harder you make it, the more chances are that it's not going to go well, right? Because it's going to be too complicated. Keep it simple. Make sure that everybody understands who's participating in it, what it is, in fact, that you're trying to do. And I still fall back on a few of the FAR principles because they're not even really FAR principles. They're good business practices. We want to be fair. The minute we're not fair to people is the minute we're going to get this thing killed, because it's going to look like we're playing favorites and look like we're picking our favorite people all the time. We want to keep it fair. We are still the government, and we are still spending taxpayer dollars, so we want to do that in a fair manner. You want to be transparent. Don't try to hide stuff. That's what angers people. We want to make sure that people understand exactly what's going to happen. And I still follow the principle that if I laid out a process in the solicitation, we're going to follow it, because that's what we told the offerors we were going to do. And until we tell them we're going to do something different, we need to stick to that process. You have a little bit more flexibility in going back out and telling them additional facts, but still, that's where you're going to mess yourself up, is when you start to deviate and you start to be sneaky. Sneaky never gets us anywhere. So just be as upfront as you can be, and everything generally will work just fine. So can you hang on, because we're taping? So just make a note. Sorry. Yeah. Okay. So some aspects that are unique to both authorities, both the OTs for Research Authority, or the TAs, and the OTs for prototypes. Both authorities allow for advance payments. So unlike traditional procurement contracting where that's really frowned upon, advance payments are specifically stated as being okay. Now, we all know from a business perspective, would you want to pay these people up front? Probably not. That probably wouldn't be a very good business plan. But it does allow you for a little bit more flexibility to give them some forward-funded cash flow if necessary. Remember, especially with the research ones, we're often dealing with startups, very small companies, sometimes guys in their garage who need a little cash flow in order to get up and going, and that's what we're trying to promote anyway. You can recover some of the government funds, and I'm going to explain how this works for a second because it sounds really exciting. It's a little bit more complicated. What this allows for is for you to sign an OT to actually recoup monies that the government has expended and bring it back into your existing agency. So let me just give you an example. When I was at DARPA, we did a project under a traditional procurement contract to build a radar that fits in the bubble on the bottom of a plane, so when the plane flies over, it can map the ground. Turned out it worked very, very well. We didn't own the plane, though, just the radar, and so when we tried to shop it around to the services, nobody wanted it. They didn't see the value of it. But the company that had helped develop it wanted to buy it from us and turn it into a business. They actually wanted to sell the maps to private sector companies and other governments, and they wanted to buy the radar from us. But how do we do that? Well, we entered into an OT that basically was a bailment. We bailed it to them under certain circumstances, specifically that they had to take it, upgrade it, maintain it, and make sure that it was well kept, so that there was no loss to it. Buy a new airplane to put it in, and show us that at the end of the year they were making money, which is actually pretty hard for a new startup company. If they could do that, at the end of the year, we would turn over ownership to them in exchange for some consideration. Now, we're all familiar with the concept of consideration, right? And we all realize it doesn't have to be money. Consideration can be something of value. They didn't have a lot of money, so instead the value that we took was we got a discount every time the government needed to use it. We got the right to pull it out of rotation if we had a national emergency, like a flood. And we got a royalty every time they sold it to somebody else, a percentage royalty. And that royalty money, under this statute, comes back into a special account that Treasury holds for your agency. It is not a miscellaneous receipt. It does not go back into the Treasury, never to be seen again, but it actually comes back to your agency, and you can use that money again. So we entered into this arrangement. It worked very well. We turned over ownership to them, and basically we capped the amount of recoupment at the amount of money we had invested in the radar. And they are still flying today, selling maps, and we basically recouped all the money that we spent on the item, rather than having it sit in the warehouse in Maryland with the Ark of the Covenant, which is where most of this stuff goes. We actually now can use it ourselves, but also it's used in the commercial world too, so it became a commercial technology. But it is nice, and it allows you to recoup some of that money and bring it back into your agency. Now, as with procurement contracts, most of you are familiar with FOIA, I would assume, right? Freedom of Information Act. So with procurement contracts and OTs as well, anytime you receive information under competitive solicitation, it is exempt from release for 5 years. Anything you receive under an OT would also be exempt from release for 5 years, which is nice for a lot of those companies who are very concerned that we're just going to turn over any information they give us to their competitors, because that's how they think FOIA works. Now, there is a chart in the reference materials in the back of this briefing that you can take a look at later that tells you all of the different statutes and regulations that do not apply to OTs. It's too long a list for us to do here, although we can refer to it if you like. I'm just going to highlight some of the major ones so that you're aware and understand, but you can take a look at that list later. The big one, obviously, is none of the procurement rules or regulations are going to apply to OTs for the most part. So the FAR is out. The DFARS is out. Any agency-specific regulations that you have are out when they come to acquisition. So basically, you toss all the books away, and you're going to start from a plain sheet of paper, which I realize for some of you may be starting to make your chest hurt, right? Because some folks, as much as we grouse about the FAR, when they take it away, we don't know what to do with ourselves in a lot of cases. And so what that means is we're going to have to think and go through all the different aspects of these arrangements to make sure that we're being covered and that we have a good business deal when we sign up to them. And please do not fall in the trap of when things get hard, you look to the FAR. Because the FAR is extremely interconnected. It's very difficult to tease out one clause from the FAR and put it in your agreement. Now, there are some good clauses in there that we've used in the past. For instance, we did an airplane OT, And we use the flight risk clause from the FAR because it's actually very well written. It's very litigated, so it's a good clause to use, rather than come up with something from scratch. But a lot of times I find that when things get tough, people naturally gravitate towards back to the FAR. You should always challenge yourself if that's your thought process. Why are we including this? We don't have any of those associated FAR terms then. So for instance, things like termination. You're going to want to have a termination clause in your agreement because you want to be able to get out. And as the government, we have to have a termination clause because we can't make ourselves anti-deficient, right? If the money runs out, we have to be able to walk. And so we need the ability to be able to do that. But things like termination for default and termination for convenience are not typically used commercial words. So you're going to want to use commercial terminology, excuse me. And termination for convenience is a made-up government thing. So when you say that to the contractor, it's going to be like, what? And imagine in the private sector, is there any arrangement you can think of where one party gets to walk away just because they don't feel like it anymore? That's not generally how that works. So that will be something that you'll have to really consider. One of the nice aspects of OTs, though, is the Competition and Contracting Act does not apply. So CICA is out the door. And CICA does several things that makes this a little bit more flexible then, right? For one thing, CICA has the various levels of competition, right? Full and open, limited, and sole source. So none of that applies to OTs. So what you're going to see in the OT statute is that the statute says we should be competitive to the maximum extent practicable. What does that mean? I don't know. The lawyers wrote that so that you can come up with whatever's practicable at the moment. But you're not locked into those 3 levels of competition and all of the publication requirements, and you don't have to write sole source justifications unless your agency determines that they want you to have some kind of documentation to justify going sole source. The other nice thing CICA gets rid of is, what does CICA do? CICA is the reason why you can have protests, right? CICA defines the 3 protest forums and lays out all the rules about protesting and the automatic stay. All of that is gone as well. Now, I will say, though, it is possible to get protested. Possible. It's very unlikely. It's happened. I can probably count on 2 hands the times that it's happened in the last 25 years. GAO has addressed OTs before, and they have said they have no jurisdiction other than to determine if an OT should have been used or was appropriate to use, which in most cases it's always an option, so that's not really going to be an issue. You can get protested to the Court of Federal Claims. That, again, has happened maybe 5 times over the past 25 years. It's not likely. I wouldn't worry about it. So protesting is really not going to be something that you're going to have to stress over too much. But we do want to make sure that we maintain those good business practices, right? We want to be fair. We want to be transparent. We want to do what we said we were going to do. Because even though people can't protest, what can they do? And you guys probably don't see this as much down here than where I live up in Virginia. They can go to Congress. They'll go to the Hill, they'll go to their congressmen, and they'll complain that they weren't fairly treated, which is another aspect of this we want to make sure doesn't happen too much. So we just want to keep fairness in the back of our mind at all times. The other nice thing about not having CICA is, remember, CICA has a tail on the back end, too, in our arrangements. CICA created the concept of scope. Scope doesn't exist in the real world. No one cares in a private sector contract. Right? If they want to add on more work, they just negotiate it and they add it on. We only care in the government world because of CICA, because CICA says you need to compete all new activities and actions. Right? That's why we do the whole in-scope, out-of-scope analysis to see whether something was part of the original award or something that is new and outside of it. If you don't have CICA, you don't have to worry about that. So we still want to be fair. We don't want to look like we're picking one contractor and then lobbing on every requirement that we have, but it does give you the freedom to not have to think about everything so much up front. So you don't have to negotiate options necessarily in order to add on additional work like we normally do, so it would be in scope. It allows you the flexibility to structure your programs somewhat differently and allows you to assess your programs as you go to see where you want to go with them. And so it gives you a lot more freedom in that regard to structure your programs well. So you can take any kind of relationship with an OT, which you actually can with the FAR as well. We just typically don't. You're not locked into a prime and a sub relationship. You can deal with a partnership more easily. You can deal with a team or a consortia. You can deal with a joint venture. All sorts of different kinds of partnership relationships are possible. And much more common to see under OTs than you would see them under traditional contracts. You just want to make sure that if you're going to do one of these, that they have arranged themselves and come together under some sort of legal document, whether it's a contract amongst themselves or some sort of filing that they do, because we want to make sure that they come together to us as an integrated team, as opposed to onesie-twosie it. Intellectual property is fully negotiable under an OT. That includes patents, which is covered under the Bayh-Dole Act, which has been around since 1980 and hasn't really changed much under procurement contracts, as well as 10 U.S.C. 2320, which is basically what the DFARS has in Part 27 when it comes to technical data. And so you can negotiate anything from, with intellectual property rights, from nothing, we take no rights, which is not common, obviously, because that's not a good deal for us, all the way up to ownership, which you wouldn't be allowed to do in most cases under these kind of statutes, and anything in between. So I will tell you that usually the most time-consuming negotiation under an OT is intellectual property rights, because they understand intellectual property rights. The commercial folks, they are well versed in it. They're very good at protecting it. They typically have a lot of lawyers who are very well paid to protect it, and so that is going to be an area that you're really going to have to sit down and think about when you are beginning your OT negotiations as to what your position needs to be for the long term. Now, this isn't a topic we could talk about for a whole day if we wanted to, so I'm sorry, I'm going to have to give this short shrift. But one advice I would give you is don't think about the term of your contract. That's what most people do, or your agreement. Most people just think about the life of the agreement when it comes to IP. You need to think about the life of the technology and assume that this is the next best thing since the internet. And it were to last forever, because Lord knows the government keeps things forever, right, and doesn't change over that often. What would you need intellectual property-wise over the long haul to make it useful for you for everything that you think you're going to need to do with it? Which is why having your program folks and your technical folks involved in the negotiations is so important. Because I'm an intellectual property lawyer. That's my specialty. But even I don't know the nuances of every one of these technologies that I've helped negotiate an OT for, because that's not my area. And as contracting officers, we tend to know contracting, right? We don't necessarily know the technical aspects. When you have to start negotiating intellectual property, you need the technical folks there, because they will understand what they need and what they don't. You may give something away that you thought was unimportant, that it turns out to be really important to them. You want to work together as an integrated team when it comes to IP. And plan as early as you can for it, because it will take a long time. You can also pay these folks in a variety of different ways. We tend to pay through what we call payable milestones, which is a more commercial-like payment method, where it's very akin to performance-based payments in the traditional procurement world, where it's based upon some observable technical event that they achieve and what we've assessed has a certain value to it, and we pay to give them some cash flow in that regard. But you certainly don't feel locked into that. There's no rule or requirement that that's how you have to pay folks. And I will say on some of our bigger system OTs, we've paid people through the normal invoicing monthly kind of way of payment, just because it was too complicated and they had too much cash going in and out to be able to sustain waiting for a few months. But there's a lot of variety of ways. Don't feel constrained by what you're accustomed to under the FAR. You can think broadly and accommodate certain kinds of instances that they have that they may need some help with. So as with all things, I'm sure you can gather, there's going to be people that are very fond of OTs like me, and there's going to be people that are very afraid of them or very contrary about them. So what's positive about them is the flexibility, at least in my mind. It gives us the ability to be flexible, to reach out to these different kinds of folks and accommodate some of their unique issues, which usually don't present us with any problems. It's just that under the traditional procurement world, we never had that ability to make that accommodation. We can attract companies that would normally avoid doing business with DoD, but I'll tell you one of the biggest problems with that is we don't know where to go find them a lot of times. You know, I've seen a lot of people do OTs and then publish their solicitation on FedBizOps. Who reads FedBizOps? It's the same people that always deal with this, right? If you want to attract non-traditionals and you want to find people that go beyond the normal business space that we have, we got to get past FedBizOps. And this is another area where your technical folks can really help you out, because they are in the industry, right? They understand who these various players are, and they know where a lot of these resources may lie in terms of advertising opportunities, whether it's through industry groups or using the internet or something like that. We've got to get better about marketing ourselves. We traditionally have not been too concerned about that because we assume everybody wants to work with us. right? And they're just clamoring to get to us. And then, unfortunately, that's not the way it is anymore. So I know this is the one that we always try to promote, this last bullet of promoting trust and a spirit of cooperation with industry, and I don't know how successful we've been over the years. You know, there's been a lot of, in our training, we talk about being collaborative as opposed to adversarial, and I think many of the contractors in the room might say that we're still somewhat adversarial. The only way that you're going to promote trust, though, with these folks is if you stick with what you said you were going to do, and you're upfront with them. So the transparency part of this will go a long way towards that. And making sure that they're a part of the process. This is really a team effort, because let's be honest, the government doesn't build much itself anymore. We rely on the contractors to come up with most of these technology innovations and build the things that we need. And so having them be a key element of the team is going to be important, but being upfront with them and making sure they understand what's going on is also going to be key here. And the OTs allow you that level of flexibility. It takes away a lot of the fear aspect of it. Remember, if you weren't worried about getting protested, would you have a lot less fear about what it is you're doing? Yeah, or a lot less concern? Yeah, if you knew that it was going to be something that you could just go ahead and do. As long as you do it well, you should have no problems. Now, the folks that are not too fond of OTs tend to be a lot of the kind of folks who think that, who are risk adverse, let's put it that way. And I find that kind of funny because, remember, this is an R&D tool. If you're in the R&D world and you're risk adverse, you have chosen the wrong business to be in, okay? Because what happens in R&D? Stuff fails. It's supposed to fail. And what's funny is that our old DARPA director used to say, if you don't have a certain level of failure, you're not pushing yourself far enough. If you're always succeeding, you're choosing too close of technologies that are already too close to being you're not being innovative enough. And so, you know, you shouldn't have too much worry about this from a risk aversion point. And as long as you are putting in good practices within your OT, as long as you're putting in the right terms and conditions and everybody's paying attention to what's happening, for the most part, you shouldn't have too much trouble. And what you will find with OTs oftentimes, especially research ones, is that there is a level of cost share associated with our research OTs in particular. Once you have that cost share in there, everybody pays a whole lot more attention to what's going on. And we have had many programs where it was pretty clear to everybody it just wasn't going to happen, that were terminated in the middle by mutual decision. And that's okay. We should probably do that more. Because what does the government tend to do in a lot of cases is we see projects going badly, we just throw more money at them, right, in the hopes that it will succeed somehow. There's a time in which you just accept the fact that it's just not going to happen. Cut it off and move on. But there's a lot of folks, too, who think if you take away all of the FAR protections, that will somehow get taken advantage of. I can honestly tell you that in all the years of audits, which we had a lot of audits, especially in the beginning, that's one thing you all should be grateful for, is that we got to suffer through that and you won't have to too much. When I first started at DARPA, GAO had an office in our building because they got tired of coming over on the Metro. So for 4 years, they had an office in our building looking over what we were doing and never found any problems. The IG had come in and, much to their dismay, never found a case of fraud, waste, and abuse. So even without all of those FAR protections, and by the way, even with the FAR protections, do we still get defrauded? Yeah, so it's not a panacea anyway. We have been very successful in making sure that we keep good watch over these things, and therefore, you know, the chance of that is much more lessened. They can be more time consuming, and I know that everybody thinks they're going to be fast. But think about it, if you have to negotiate all the terms and conditions and you're not accustomed to doing that, there's going to be a learning curve associated with this, and especially when it comes to intellectual property. And especially if you don't have an attorney that knows much about intellectual property and you have to go hunt one down. So, and if you put your OT through your normal procurement process for approvals and all that, it's not going to save you any time, right? I have seen people do OTs and do a Part 15 source selection and then run it through the procurement process for approvals and then tell me that they don't understand why people do this because it's not any faster. Well, no, of course it's not going to be any faster because you put it through the same process you already have. So this is going to be an area where, you know, you may need to convince your management. It may have to have a separate process or come out of the process if speed is something that you're really shooting for. But I just want to make sure that y'all understand that speed is a side effect once you embrace the flexibility. If your organization is not willing to embrace the flexibility, it may not be any faster. Now, you may still achieve the same goal, the main goal, which is to find the non-traditional contractors. But if speed is what you're really shooting for, you kind of have to work on that in order to make that happen. So, just very quickly, the original authority at 10 U.S.C. 2371 is called TIA for a variety of different reasons within DoD, and I won't get into that because it's too hard to explain. But this was the original authority that was given to DARPA back in 1989, and then to the rest of the agencies in 92. And it says the Secretary of Defense and the Secretary of the Military Departments may enter in transactions other than contracts, cooperative agreements, and grants. So that's how we got the name other transactions. We were not being very creative that day. So it's other transactions because it's something other than. So it's defined in the negative. So lots of people want me to define what an OT is, and I really can't. All I can tell you that it is it's not a traditional procurement contract, a grant, or a cooperative agreement. It can be a host of other things, but it's not going to be one of those. And they were created to carry out basic, applied, and advanced research projects. So that's why I try to emphasize this is a research tool. So the whole idea in this original authority was to focus on dual-use research projects. And when I say dual-use, I mean technologies that had the capability to have a commercial application as well as a DoD application. And that's why you'll see in this original authority there is a cost-sharing requirement. So the cost-sharing requirement said that the funds provided by the government does not exceed the funds provided by the other parties to the transaction. So in other words, the goal was a 50-50 cost share. The thought being that if it's truly dual use, they will see a commercial market for it. We see the government market where you work together, and they'll be able to recoup that when they start selling commercially. Now, you'll notice it says, to the extent it's deemed practicable. Again, lawyer wiggle words. What that gives you is a bit of an out. So 50-50 is what we're shooting for, but that doesn't mean that it always has to be 50-50. If it's not practicable because of their circumstances, what we're looking for is commitment on the part of the other party. Commitment to commercializing, commitment to putting the effort into developing this technology. For some companies, especially small startups, that could be as little as 5 or 10%. But it shows a tremendous amount of commitment on their part to make this successful. So don't feel constrained necessarily by the 50-50. That's certainly what you want to try to achieve, but you're not locked into it. Now the current FY18 NDAA also put in some education and some guidance requirements, which is why I'm at DAU now, to help facilitate that. And so in many ways, this is like other things we've seen over the years. You know how they had cores for a long time, but no core training, and then they suddenly decided to train them. Same kind of thing. They're realizing that this is becoming a more common tool, and people need to be trained, and we want to offer that. Now, because these are more assistance kind of arrangements, so these are not focused on actually acquiring a good or service, but they're focusing on supporting and stimulating some activity for the general public good. It is considered assistance within DoD right now, and it is covered by Part 37 of the DoD Grants and Agreements Regulations, or the Dodgers. So there is a level of guidance provided there that you can go take a look at. It's fairly top level, and I'll be honest with you, it's going to be rewritten because all of the Dodgers is being rewritten. For those of you who do grants, I'm sure you're familiar with that. So you can go there and you can get a little bit more insight into how to do one of these OTs for Research, or TIAs. But again, these are not as popular in recent years or as common, but we're starting to see these being used more and more, and particularly where I'm seeing some agencies use them is when they start to deal with big pharmaceutical companies. Because big pharmaceutical companies want nothing to do with us. They have no interest in our money at all, but they are willing to do some research projects if they can do them under OTs. And so we're starting to get a little bit more inroads with those big pharma companies. So the one most people are used to is 10 U.S.C. 2371B. And I educate people on the first one only because what most people don't realize is that the OT for prototype authority is actually built upon the first one. It says, under certain circumstances, DoD can use the authority of 2371, so that research authority, and extends it to carry out prototype projects that are directly relevant to enhancing the mission effectiveness of military personnel, blah, 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 blah. So it's taking that basic research authority and extending it to allow you to acquire a prototype. So when we extended it, we stepped over the line from assistance into procurement. Because when we acquire a prototype, we're actually acquiring some good or service for the general, directly for DoD. So this falls more into the acquisition side of the house, where the other one fell more into the assistance side of the house. Now, it's given to the Secretary of the Military Departments and certain specific agencies like DARPA and MDA. But for everybody else who's part of the Fourth Estate, you have to go and ask for permission or delegation from OSD. And this is a list of the agencies that have currently been delegated. And MDA shouldn't be even on here because you're not delegated, you actually have it. who have already asked for this authority, and there are more asking for it as we speak. So if you are part of an agency that's not part of the military departments, you will need to go to OSD and ask. And from what I understand, it's not a very traumatic ask. It just may take a little time for them to get back to you. Okay, so I only show this because there may be some of you who are used to OTs or have been around this for a little while, and you remember OTs being called Section 845 agreements. Some agencies called them Section 815 agreements. And the reason why they had all those section numbers is that was a section of the public laws that they were created in. In FY16, Congress finally made this a permanent authority. Up until that point, it had been temporary, and it had just been extended every 3 years for the past 20 years. FY16, it is now permanent and therefore codified. So I'm trying to get everybody away from using any of the section numbers anymore because it's confusing for folks. Instead, we now have a statutory citation we can use, and that's what you're going to see throughout all of the stuff that we put out, is 10 U.S.C. 2371B. Okay, so 2371B has some specific unique requirements. It says that we should be competitive or use competitive procedures to the maximum extent practicable. I'm sure you're starting to see a theme here. There's a lot of outs within the authority that allow us to have a lot of discretion as to what is considered practicable. I will tell you, though, I could probably, in my career of doing OTs, have done maybe 10 or 15 sole source OTs. I'm not a fan because competition is a good thing, right? What does competition do for you? It keeps quality high and prices low, and let's be honest, we oftentimes in the federal government don't really know who's out there. We think we do, but we don't really because we're fairly insulated and we go to FBO all the time. Once you start opening the door and you get a lot more flexibility built into your process, you will be surprised who comes out of the woodwork. And for the contracting folks in the room, I know what you hear from the technical people because I used to hear it too. Well, I know everybody who's out there who does this kind of work. Why are we bothering doing this? My very first OT was an airplane called the Global Hawk, which you guys have probably heard of. Fortunately, it was one that actually succeeded, which they don't always. When we first started to do the Global Hawk, that was the first big OT for prototype. It was the first OT for prototype at all, actually. The tech guys told me there's only 5 companies in the world that can make this plane. So let's just go to the 5. I'm like, you know what? Once we've gave them all this flexibility, let's just throw it out there and see. We won't run the competition for too long. You know, we won't leave it out there on the street for too long. But let's see who's out there, and if there's only 5, then we'll get 5 proposals, right? No skin off our nose. So we threw it out there, and we got 14 proposals from companies that some of my guys had never heard of before, but who were actually legitimately qualified potential offerors, and including some companies who never deal with the government, like Burt Rutan, who won the X Prize at NASA, who flew the plane around the world, had sworn off ever doing an R&D project with the government, but once he realized OTs would give him the flexibility he needed, he submitted a proposal. So you will be surprised who comes. Now you'll get the weirdos too that come out of the woodwork too. You know, the ones that you're looking at them thinking that's never going to happen. But you can weed those out. But it's good to throw these out there and just see who might be interested once you give them all of this flexibility that may never have considered the government before. So under an OT for prototype, unlike an OT for research, under the OT for research statute, you have to actually write a justification as to why your contract, grant, or cooperative agreement wouldn't be feasible or appropriate. Don't call it a J&A, just call it a determination or something like that. You do not have to do this under an OT for prototype. You can decide to do an OT for prototype even when a contract would be perfectly acceptable. Because a contract obviously would be perfectly acceptable because of the nature of what you're doing. You can just go ahead and do it just because you want to try out an OT and see if it would work. Now, interestingly enough, and we're not sure how this will shake out, so I'm just going to mention this, but I can't really give you any guidance as to how this is ultimately going to work. In the FY18 NDAA, there is a section that requires the Secretary of Defense to establish a preference for the use of OTs and experimental authority under a different statute in the execution of science and technology and prototype projects. So basically what this means is you are supposed to consider OTs first before you consider any other kind of award instrument. Now, he hasn't actually established a precedent or preference yet. And how that would be accomplished, I'm not entirely sure. I'm assuming it would be accomplished through some kind of memo or policy statement. It has not happened yet, but that is in there. And so that's obviously something Congress feels was important enough to stick into the bill And we may see something come down the pike that will change a bit on how you make your decision about what it is you're going to do when you're faced with a S&T or a prototype project. The statute also requires that the Comptroller General have access to information and the ability to review any agreements in excess of $5 million. I would argue that they have this anyway because they can always review any agreement where they receive federal funds. But they're very specific about including it. I can tell you, though, since that has been added to the legislation, I don't think the GAO has ever come in. But it gives them the ability to. So it's their little safety net to allow them to do it. Also, the Procurement Integrity Act now applies to OTs for prototypes. I'm assuming everybody went to ethics training, right? Right? Yes, I used to be an ethics officer, so I always check. And I'm sure that you paid attention to the procurement integrity part, right? Well, you should, especially if you're thinking about retiring, because it could really impact you. But prior to, I think it was about 15 years ago, the Procurement Integrity Act did not apply to OTs because OTs are not procurements, right? So anything that said procurement on it, we would automatically discount. Well, then the Air Force had a little trouble, as I'm sure you recall, where a certain important person at the Air Force ended up going to jail. And one of her big projects had been a program called EELV, which has been a very successful project. It's, I always forget the acronym, Expanded, Emerging, Evolving, something, a launch vehicle, yeah. It's basically a way to establish a launch service platform for the United States. It's been very successful. It just so happened that she was in charge of it. It had nothing to do with why she went to jail. But because of that, Senator McCain said, ooh, she was doing OTs. Maybe OTs need to have the Procurement Integrity Act applied to it so people will feel that level of concern and we could obviously send people to jail. I don't think that I think she would have gone to jail regardless because obviously she ignored a bunch of other statutes. But now the Procurement Integrity Act applies to OT. So if you're going to be a program manager on another transaction and you're thinking about retiring, you need to consider the OT along with your procurement contracts as to whether or not you'll have some restrictions. Okay, so over the years, well, about 10 years into the OT for prototypes being in existence, the Congress decided that there should be a higher level of approval actions that were taken for the bigger OTs. Since then, the OT approval thresholds have grown and grown and grown. So prior to FY18, this is what they were. And I only put up what they were just because it happened so recently that some of your policies may still have these old thresholds in them. What is current now is that if it's under $100 million, it does not have to go any higher than the CO unless your organization decides to input their own approval thresholds in there. But as far as the statute is concerned, it's $100 million. If it's $100 million to $500 million, it would go to your senior procurement executive. Now, down here we have a little box just because not everybody has an SPE. So for instance, like at MDA, it goes to your director. DARPA went to the director because it's such a flat organization. The military departments, it would go to your head SPE, so that would be the one in the Pentagon. And then for everybody else, you would look to your specific delegation, and in your delegation it tells you who the approval thresholds will be. If it's over $500 million, it needs to go to AT&L. Now, I am aware there is no AT&L anymore. We have not changed this only because the statute still says AT&L. And there has been no decision yet within the split where these approvals are going to fall, whether they're going to fall on the R&E end of things or on the ANS end of things. So until we hear that, we're still keeping it as AT&L. Also, you have to notify the Congressional Defense Committees 30 days before signing the agreement. Now, this is an extremely high threshold, so I don't anticipate too many folks reaching this level, but it is important that you're aware of this because it does take some time to get all of these approvals done before you can award your agreement. Okay, so under the statute, in order to enter into an OT for prototype, you have to fulfill one of these 4 requirements. Only one, though. It's not all. And it's not technically a hierarchy either. You can skip down the list. But it does show you where Congress is placing their emphasis when it comes to OTs for prototypes. So if you have at least one non-traditional defense contractor or a nonprofit research institution participating to a significant extent in the project, then you can go ahead and sign the OT. You're fine. The rest of the team can be traditional guys. Now, in a second, I'm going to tell you what significant extent means, and I'm going to tell you what non-traditional means in terms of the definition. The second one, which I kind of believe is kind of an because if you have the first one, you have the second one. All significant participations in the transactions are small businesses or non-traditional defense contractors, including SBIR participants. That was added in last year because SBIRs are traditionally done under traditional procurement contracts. Are you all familiar with SBIRs? Small Business Innovative Research? We have always questioned why that is. And there was some debate about whether OTs could be stretched that far, so Congress stuck it in there. So you can now do OTs for prototypes for your SBIR awards. If you decide you don't want to do traditional procurement contracts, it actually makes a lot of sense. They're very non-traditional usually, and they're very small, so why saddle them with all that stuff in a procurement contract? Or, if you don't have one of those two, then at least 1/3 of the total cost of the prototype project is paid by a source other than the federal government. So this is the infamous cost share requirement. So if you just have traditional guys and they haven't gone out and found any non-traditional partners, then they will need to pay 1/3 of the total cost of the project. And what they mean here is you figure out how much the reasonable cost of doing the project would be, and they would pay 1/3 of that, not the cost of the project plus 1/3, because that engenders some concerns about buy-ins and some things like that. Or, if all else fails, and you can't meet any of these, then your agency SPE can determine exceptional circumstances justify the use of the authority. I have not seen anybody do that yet, because this is one of those areas, you know, if the world's going to end, you can go ahead and do it. I can't imagine a situation where you couldn't fulfill one of the other three. But, you know, just in case, there's always that one there. And more power to you if that's the one you choose to try to use. So what's significant participation? Because remember it says a non-traditional defense contractor has to participate to a significant extent. Significant has never been defined anywhere on purpose. Because what's significant in one circumstance may not be significant in other circumstances. So if you look to the OT for Prototype guide that DPAP has put out, which is on their website, you'll notice that it's fairly top level, but it does address some things like this. And so significant participation could be a material reduction in the cost or schedule. So whatever they're bringing to the table would bring down the cost or schedule. An increase to the performance. So their participation is key to making the prototype work as well as it does. They're bringing in a key component, a key technology, a key process on the critical path. So in other words, they're doing something that without their participation, the project would be lesser or not as successful. Again, these are just some examples, certainly not the only example. I would think broadly on this, but you want to be able to justify that what they're doing is somewhat significant, because otherwise it could look funny if someone comes in and audits you. I'll be honest with you, most of the time, most folks will ask as part of their solicitation for the teams to identify who their non-traditionals are and what is their significant participation. So make them do it, and then you can assess it without having to do the assessment yourself. What I don't want people to focus, though, on is how much money the non-traditional's getting, because that's irrelevant to this. They may only have a very small part of this, but their part is key to making this whole thing work. So try to get off the money aspect of it. I've seen several agencies who will put percentages on this, say they have to get at least 10% of the money or something like that. That's sort of an artificial construct. Just because you're getting 10% of the money doesn't mean you're doing anything exciting in this whole scheme of things. So just focus on instead what it is they're bringing to the table. Don't worry if they don't participate in the whole project, because they may be able to do their part of it and then they're done. You wouldn't have to, carry them along through the whole thing just because you want to have them there. And make sure that the non-traditionals are actually doing something and not just being fake. This is a little bit like when you had the small business set-asides and the small business where you're looking for small businesses. You don't want them just to be placeholders. You don't want them just to be fronts and then not have them actually do anything. So your analysis needs to be documented, as with most things. So again, I would punt it a bit to the offerors, let them do the work in their proposals to you, and then you build upon that and do your own assessment. Okay, so what's a non-traditional defense contractor? It's not actually defined in the OT statute, which is what's confusing for a lot of folks. So I gave you the citation up here. It's in 10 U.S.C. 2302, subparagraph 9. And what it says is that it is an entity that's not currently performing or has not performed in the last 1-year period preceding the solicitation by the Department of Defense any contract or subcontract for DoD that is subject to full CAS coverage. CAS is the cost accounting standards. Some interesting aspects to this. So it's 1 year. It's a relatively short period of time. It's any contract or subcontract. So if they normally get grants or cooperative agreements, not going to factor into this, just procurement contracts and subcontracts. Full cast coverage is really high. And actually, the statute used to say full cast coverage or subject to certified cost and pricing data. Certified cost and pricing data threshold was $750,000 at the time. And we asked Congress, that's really low. SBIR participants in a phase 2 will get more than $750,000, which would make them traditional, which they're obviously not. So what Congress did in FY16 was they took out the certified cost and pricing data threshold and just left it at full cast coverage. For those of you who may not be aware, for most purposes, full cast coverage is $50 million in a single contract or a combination of contracts. That's a huge threshold now. That's why I say I would be surprised if we would need to have many teams cost share anymore, because you should be able to find a partner that got less than $50,000 or $50 million. Because of that, if you're a small business, a legitimate small business, you will always be a non-traditional, because all small businesses are non-cast covered, full cast covered. And so in most cases, if you reach a $50 million threshold, you're going to go out of your NAICS code anyway. So all small businesses are non-traditionals. What's also interesting is the statute originally said any contract or subcontract for the federal government, but they changed it to DOD. So what does that mean now? So if you're dealing with a contractor who normally has contracts with NASA or DHS or Department of Energy, none of those count. It's just DOD. So they could have $100 million worth of contracts at NASA, and that would not factor into this equation. So they're focused very specifically on those traditional DOD contractors. You can tell. So can you see what I mean when I say this got a lot broader and the non-traditional pool suddenly got a lot bigger? Yeah, and I can't imagine if somebody's we're looking with half an eye, they shouldn't be able to find a team member who's a non-traditional. Okay. All right, so this is the one that's exciting, everybody. I'd hold off on your excitement for a little bit, just to be careful. So about 15 years ago, Congress actually gave us follow-on production authority to an OT for prototype. It's been in the statute for quite a while. But they did it really funny, and it wasn't useful. The original authority said you could do a follow-on production OT to someone who had an OT for prototype if at the time of the original award of the OT for prototype, you defined how many you were going to buy in production and at what cost. Okay, really? So you haven't even built the thing yet. You don't know if it's going to work. You have no idea how much it's going to cost, but in order to use that follow-on authority, you had to dictate all that up front. It was ridiculous, and nobody ever did it. And ironically, the staffers asked us, why isn't anybody doing this? We're like, have you read it? I mean, how would you possibly do that? And they agreed. And so in FY16, they gave us a change in the language, which has made it much more useful. But there's going to be a lot of things that we're going to have to think about before we actually delve into this world, because once you start into the production world, you have a whole host of other associated issues that you're going to have to start to deal with. So now you can go into production off of an OT for prototype if the follow-on effort will be awarded to the same signatories to the original OT for prototype. So you can't suddenly change team members. Now, if you had a team or a consortia that was the original signatory, it would be the same consortia that could carry on through. Now, there are some consortia that are being run kind of like IDIQ agreements out there. And so the statute does allow for those folks who got subawards under some of those to get the follow-on. So they would be considered the signatory as well. You had to have originally competed the OT for prototype. So it couldn't have been a sole source. But they don't define what competition is. So in my mind, if you threw out a solicitation and only one person offered, it's competitive. I mean, just nobody cared. So that would be fine. That hasn't been challenged yet, so we'll see how that goes. But that's the argument I would take. And, you know, in the duh category, the prototype was successful. Well, duh, why would you do it if it wasn't? That's sort of a non-entity. So how would you do the follow-on effort? The statute gives you several options. It says you could extend the original OT for prototype and just go on into production. Just add on the additional work and keep on going. That would be a nice option for some things, like some of your bigger system contracts, because what it would allow you to do is pre-negotiate price while you still have competition at the later stages, and you would never have a gap. You would just keep on going, and the price would already be established. You don't have to renegotiate. You could end the original OT for prototype and award a new OT for production. But again, that's going to create a gap to some degree. And once you reopen negotiations, what can happen? The price is going to go up. Terms and conditions are going to change. You could end the original OT for prototype, and you could award a procurement contract. Again, same kind of issues and same kind of concerns. Or any other procedures the SecDef may establish. So we'll wait and see what he or she establishes. But the beauty of this is you're not required to go back out and recompete for any of these options. So even if you choose to end the OT for prototype and award a procurement contract, there is no requirement to recompete, write a sole source justification, none of that. You just would keep on trucking. And it would not be the subject of a protest because legitimately under the statute you could do it. Or the OT for production, but you'd be less likely to get someone complaining about that. It would not be considered a sole source award. So I think you can see the value that a lot of people are starting to think about this. But just remember, this is going to be a very different animal than the OT for prototype, which lives in the R&D world, right? Now when you go into production, you're going to have to start thinking about things like the 5000 series, if it's big enough, and how it's going to fit within legacy systems, and how it's going to work within legacy logistics, and other things like that that we haven't ever really addressed when we're just dealing with prototypes. And so that's why I say this is a little bit of a moving animal here as to how this is going to be done and how the OSD is going to look at it. They're still in the process of thinking about policy, and then how different organizations are going to use it. As far as I know, and I've talked to the folks relatively recently, there's only been 3 of these that have been done. They've all been by DIUX. Other than one of them, they were relatively small. There was one that had some issues, which actually doesn't surprise me, because anytime you try something new and different, you're bound to have some hiccups along the way, right, and some learning curve. And so this is an area that I think you're going to see some evolution, but it's also an area you really need to sit down and think very carefully, because a lot of the lessons learned and a lot of the guidance that we've come up with doesn't really address this end of things, right? Because it's always been R&D driven. This is going to be a whole different kind of animal for many of your organizations. So I would anticipate seeing, if I were to guess, that different organizations will have different approaches to doing this, just because they have different ways of handling production purchases, depending on what it is you're buying. And obviously, you're going to buy an airplane very differently than you would buy software in production, right? There's going to be a lot of nuances that are going to change things, depending on what it is you're trying to buy. Okay, so some best practices for the OTs for prototypes. We won't talk about the production ones. So the primary goal, yet again, is to attract non-traditional performers. It is not about being fast. Fast may be a happy side effect, but it is really about attracting those non-traditional performers. It may not be faster. There is a definite learning curve. And so this is one area that I think you're going to find the first few may take you a little while, just because you kind of get used to the idea, trying to get people acclimated to the fact that there is no FAR anymore, and learning how to negotiate. And so this is something that we typically would recommend that you pick more seasoned contracting officers who tend to be a little bit more confident in their abilities and have seen, good business practices in the past. But sometimes the more seasoned contracting officers are also more wedded to the FAR. So you're going to have to gauge within your own organization who's the best people to do this. And I will tell you, even at DARPA, which tends to be very out there anyway, we still had COs who really never did OTs because they just could not get past the compliance aspect of it and the traditional way of doing things. And so it may be that you have to sort of suss through your pool of folks that you have to pick out certain people who are going to be better at this than others. Okay, again, I would highly encourage you to work as a team. I've never seen this work super well when you didn't have people working closely together as a team from the very beginning. I mean, even pre-solicitation. Lawyers, contracting folks, and program folks. Because that's the only way you're going to make this go quickly. If you do sequential contracting like we often do, where the tech people do their thing and throw it over the wall, and the contracting does their thing and throw it over the wall, the lawyers, that's going to take a long time, and you're going to have a lot of redundancy. So if you want this to move quickly, and it can move quickly. I mean, we did major weapons system OTs where the original phase, from the time we issued the solicitation until we got the first awards in place, were like 4 months. You can do it fast. You just got to work together as a team and be focused on it. Marketing is the biggest problem that I've seen over the years. That's one area that DIUX is doing very well, to be fair. That's one of their major focuses, is going out and making those relationships and marketing. But that's something the rest of the agencies may find a little bit more difficult, just because we're used to dealing with our traditional DoD contractors. How do we market this? So I would team up with your tech folks. You know, where do people look? You know, what would they read? And it's going to be different for every different industry. If you're dealing with the software types, they're going to do everything online. You send them any paper, they're not even going to look at it. I would highly encourage you too, whatever you put out there, especially to the cyber software types, make it look as little government-like as possible. Because they see us as the men in black who are going to come in and like implant chips in the back of their head. They want nothing to do with us. So I would use the internet to the best resources that you have. Not the dark web probably, but the rest of the internet, because it's fast and it's cheap and it reaches a lot of people. And so that can be a very useful way to get to folks. But I can tell you that over the years, this has probably been one of our biggest challenges, is how to find the right people to reach out to and get the word out to them and not scare them along the way. It is not appropriate for everything. I know everybody sees it as this great panacea to the substitute for the FAR, and I will tell you the guy who created OTs always viewed it as a substitute for the FAR. Never going to be one unless things dramatically change. It is an R&D tool. Think about the two statutes. One is focused on basic, applied, and advanced research, and the other is taking that and taking it into prototypes. The production end of things is sort of a natural extension, but this is really an R&D tool. So if your original acquisition is not going to be something R&D like, this is probably not the tool for you. But there can be some creative arguing, right? There can be some creative situations that you can come up with. I just want everybody to be a little bit careful, because the thing that's really going to kill OTs if we're not careful is using it for things that it's not appropriate for. And look like you're doing it to avoid the FAR solely or avoid competing, because Congress hates that when we don't compete. They want us to compete. This allows you to compete without having to go through the whole rigmarole of the Part 15 and all that. But we want to make sure we use this for the appropriate situations. And be fair and be transparent. We have yet to have too many situations, at least at DARPA when I was there, of people going to the Hill complaining about our OTs. And I think that's because we always did debriefings, even though you don't have to. You probably shouldn't call it a debriefing either, but. And we were very upfront with people. We showed them exactly what we had come up with about them. We were extremely transparent with them, and we're willing to sit down and talk to them. And that's really what people want. They view generally our processes as being very dark and mysterious, and they don't really know what happens, and it takes a long time, and then all they get is a little notice that say you didn't win. You know, they don't understand a lot about what's going on. So the more fair and the more transparent you can make this process, the better off you'll be. But because of that, you want to make sure what you're doing, you're actually doing it, or what you said you were going to do. Okay, okay, a couple uncertain things. I get calls daily, multiple calls daily. Do you have a checklist for doing an OT? No. And in my mind, there's never going to be a checklist for doing OTs, because I'm not sure how I'd come up with one, to be honest. Because are they all going to be the same? No, they're all going to be different. Do you have a model OT? I actually do. I don't like to give it to people. Largely because people turn it into a form, because we're used to the FAR, right? And we get the forms. The model was created, I'll tell you how the model was created, first of all. When we first started doing the OTs, you know, contractors, and I'm sure there are contractors in the room, they'd always complain to us, well, you know, if you got rid of the FAR and you just let us do our own thing, we'd come up with really great contracts. You know, we're just stifled by the FAR. So when we started doing OTs, we said, fine, FAR's gone. Have at it. Submit your best. And within about a week, we're getting call after call after call. Do you have like a sample? Because we don't really know what to say. I'm like, seriously? All this complaining and now you need a sample? It's hard for people to start from a plain sheet of paper. And I realized that. And so we do have some models that we've sort of tenuously shared with people, only because we didn't want to send it out there as sort of being the only way to do things, which is what people have a tendency to look to it as, or as a form, with just fill in your name here and don't think about it. We want people to think about the terms and conditions, make sure that they're appropriate for their circumstance, come up with their own models or their own templates that they like. I am putting together, just so you're aware, a more comprehensive OT training that's 2 days, where I actually walk you through a model to show you the terms and conditions that are most commonly seen. But again, I really struggle with sending out models just because this is not one of those areas where it's just a fill in your name here thing. We want you to put your good thoughts to use and come up with circumstances that fit your own situation. There is very little guidance about OTs, and that's always been on purpose for the same reason. Am I going to be able to tell you how each OT is going to go? No. Am I going to be able to give you a regulation or guidance that's going to affect every single OT? That'd be difficult. You know, we have general overarching principles, and if you go on the OSD website, you can see the OT for Prototype guide that DPAP has put out, and it's very top level because of this. We want to give people the flexibility to do what makes sense for their particular circumstances. So if you're wondering when more detailed guidance is going to come out, you'll be sitting for a while, probably. This is just to take that and run with it. As I said, the new follow-on production language is still in its infancy. I suspect that we're going to see some failures. In fact, I would expect to see some failures or some circumstances where we could do better. Best practices are still going to come along because we just haven't done enough of them yet to understand what's going to make the most sense in implementing these. And, you know, even though you can do something doesn't mean you should. So if you run across a circumstance where even at the end of the OT, you look around and you realize what you've created is maybe a commercial item, that there's a lot of folks out there who offer the same thing. Should you go sole source to these people, or should you put it out for a competition and just have them be one of the players? I don't know. It may not make sense to go sole source because you may have people complaining, right? They didn't get an opportunity to participate. They may not have realized that that's where the research project was going because we didn't tell them that. There's a whole host of situations you want to sit down and contemplate. And so even though you have the ability to do a follow-on, you know, think carefully about it. See if it's going to make sense. See if it's going to engender some complaining from the private sector. See if it was truly fair to do that in that circumstance. And I would just caution that. There will be more oversight, I guarantee it. Only because OTs have become much more popular again and a lot of people are using them. As I said, when we first started doing these, we had a lot of oversight because they were new and different. That kind of died off as a lot of people were doing them, and then a lot of people stopped doing them, so there wasn't a whole lot of interest. But now the swell is back up again. Lots of people interested from the audience and the people we had to send away. Clearly, lots of people are interested. The more interest there is and the bigger the OTs get, the more likely it is you're going to have some folks that want to come in and take a look. So I would expect to see GAO show up at some agencies, especially who are going to do big OTs. I would expect to see the IG show up. It's a natural thing. Don't worry about it, though. Please take it from experience. I lived through that for 4 years with DARPA, and then I did it again at DHS when I went over there and we started doing OTs and had GAO all over us. It's not necessarily a bad thing. You just want to make sure that when you do your documentation, you fully explain your rationale for why the approach you took and why your acquisition strategy made sense to you at the time, which, by the way, may turn out to be totally wrong later, but at the time it made sense, and what you've done to monitor the program to make sure that you're being a good steward of taxpayer dollars. And again, I can tell you, with GAO especially, if they come in and they point to one that didn't go well and you explain everything that happened, and then we saw that it was not going down the right path and we took care of it and terminated it, and we'll learn from this, they're fine. What else are they going to say? You just have to be prepared for it. So don't be afraid of it, and don't not do them just because you might get oversight. But just be ready for when those folks come in. And especially be ready because they may not come in for several years after it's over. Learn that the hard way too. Document for future generations because you may be gone, right? You may have retired or run off or something. And those other people will have to justify what you did. So make sure that your file tells a good story. Otherwise, you're going to have some explaining to do later on down the pipe. Okay, so I think we've already hit all of these things already. So I'm going to have you can go ahead and end the tape here, and then we'll open it up for questions. And I'm sorry I had to hold you all off, but